Okay, welcome everyone to the Lake County District Attorney's Candidates Forum for tonight. My name is Elizabeth Larson and I'm with Lake County News. And joining us tonight are the two candidates in this year's race. We have with us Stephen Brown and Susan Cronus. Thank you both very much for being here tonight. This has been a busy season for both of you, so we're grateful to have some time with you this evening. Over the next probably an hour and a half, because we have so many questions for the two of them, we're going to let them discuss policy, we're going to let them discuss their ideas for the district attorney's office, and a variety of other things. I want to quickly thank our co-sponsors for tonight's forum, the Lake County Economic Development Corp. And the Lake County Bar Association, both of which have been great partners. This is actually the fifth and final forum of the primary season that we've done. We'll probably be back in the fall with council races and such, but this is the last one for the main races. So we're grateful to our co-sponsors for helping us through this process. So let's get right to it, because as I've said, we have a lot of great questions and we have a lot of interest in this year's race and we want to hear from them. So let's get started with opening statements. Each candidate gets a minute just to introduce themselves before we move into the main part of the evening. And we go in alphabetical order for opening statements. So again, each will get 1 minute. I'll be timing up here and I'll be noticing them with cards about their time constraints. So to get started, we've got 1 minute, and Stephen Brown.
Thank you. My name is Steve Brown and I'm running for the office of Lake County District Attorney. For those of you who don't know me, I'm from Lake County, born and raised. My family has been in Lake County for 5 generations. I graduated from Kelseyville High School. After graduating from high school, I attended William Penn University in Iowa on a wrestling scholarship. After graduating from William Penn, I moved back to Lake County and I worked as a bail bondsman, and I attended Empire Law School at night. I graduated from Empire a year early and took the bar and passed, and I've been practicing law for the last 8 years in Lake County. And I've been in private practice as a private attorney. For the first 3 years that I was in private practice, not only was I a private attorney, but I was also one of the attorneys that contracts with the county to represent people who are charged with crimes and who cannot afford the services of an attorney. So essentially as a public defender, during which time I handled approximately 1,000 criminal cases. I left the public defender contract in 2013, and since that point in time and up until currently, I've been handling a range of civil and criminal cases. Thank you.
Thank you. Sorry, that minute goes quick.
Yes, it does.
Susan.
Thank you. Well, my name is Susan Cronus. I'm a current Deputy District Attorney. And I want to say that this election for DA this year is a very important choice for the people of Lake County. I think I'm the best candidate. I have the training, the trial experience, and the temperament to lead the office for the next 4 years in Lake County. When I talk about training, I've had extensive training through the California District Attorneys Association. I've been trained on prosecuting all major felonies, misdemeanors. I have had advocacy training, as well as sentencing training of all the laws and changes we've had over the last few years. I've had extensive trial experience, and when I talk about trial experience, I'm talking about jury trial experience. I've done over 100 jury trials. My opponent has done none, no jury trials. And jury trials are the bread and butter of prosecutors. And my temperament, and I'll talk about my temperament later, maybe.
We'll give you a chance to get back to that.
Okay.
Thank you. Okay, let's now move into the questions. We determined by coin toss the order just to start, and then we rotate back and forth. So Stephen won the coin toss and he elected to let Susan go first. So we will start with the questions. Again, you each have 2 minutes, and I will cue you in with the yellow card when you have 30 seconds left, and then just finish your thought when you see the red card. So Susan, we'll start with you. First question. It's your first day in office as district attorney. As you sit down at your desk, what is your number one priority?
Well, my number one priority, and this is the reason why experience counts in this election, is I can get going day one. I know what the job entails. I know what needs to be done. Obviously, the courts court cases don't stop, the crime does not stop just because a new DA comes into the office. So I can get started day one and transition into the position of DA right away. One of the first things that I will do is I will sit down with everyone in the office, tell them what is expected of them, and get suggestions from them and comments about them. I'll meet with them individually. I will also establish policies in regards to sentence bargaining, plea bargaining, how we're going to handle cases, and I know a lot of that is ongoing, but I will make it clear what my requirements will be.
Thank you. Stephen.
Thank you. I will be honest with all of you, I did not have a lifelong goal of running for district attorney. It was something I've enjoyed being in private practice. It was something that I decided to do toward the end of last year. And the reason that I did it is because in my handling of criminal cases and in my representation of a number of crime victims, I observed that the district attorney's office is being mismanaged by the current district attorney in many different ways. There are serious cases falling through the cracks. Cases are not being prosecuted aggressively, fairly. Cases are not being charged or prosecuted on the merits. And crime victims are being neglected and deprived of justice. And it's something that I felt very strongly about. And I went around and asked a number of people who I thought might be good for the position if they were going to challenge the incumbent, and they were not for their various reasons. And I received a number of requests from people, in particular in law enforcement, to run against the current district attorney, and so I decided to do that. Though I don't know that there's any one priority that I have, I think that there are a number of very important things that need to be corrected. The current district attorney does not treat the job as a full-time position. He handles private cases out of county. I think that even though that's legal, it is a waste of your tax dollars when he's being paid a full-time wage to do a full-time job. I will treat the position as a full-time position, and I will be there to provide the oversight that needs to be provided in order to ensure that cases are prosecuted, as I said, not only aggressively but on the merits, that people aren't being given preferential treatment, that people aren't being permitted to contribute funds to a charity, of the DA's choosing in order to avoid the consequences of their criminal action. And in terms of experience, my opponent says that she has done over 100 jury trials.
You can finish your thought.
I would just be cautious about that and really look to what she says. Last year she did 2. My opponent has said in previous debates that she has prosecuted hundreds of thousands of cases. But I pointed out in the last debate that even if you take 100,000 and divide it by the 25 years she's been in office, that's 4,000 cases a year. And the DA's office, all 13 attorneys, only prosecuted 3,500 last year, so it's not even close to possible.
Thank you. Okay, next question. We'll start with Stephen. If I can get my iPad to work. Okay. Please describe your experience as a supervisor and or administrator. How many attorneys have you supervised? Where and in what capacity?
I have not supervised any attorneys. I do work in an office in Lake County that is the oldest law firm in Lake County, and we're very successful, and I'm very proud to work there. There are a number of individuals who I think we have one of the largest, if not the largest, law firm in Lake County as well, and there are a number of individuals who work and complete tasks at my direction and who I have trained to do various things. I was appointed 2 years ago by the governor to the Lake County Fair Board, which is directly related to practicing law, but on the board we oversee the CEO and indirectly the various employees that work at the fairgrounds, and administer the budget, which is something, again, my opponent has experience in the DA's office, but it's not just prosecuting cases that's important. The district attorney does many important things. Prosecuting cases is a small piece of that. In fact, the current district attorney in his 8 years, I think, has prosecuted maybe 3 or 4 cases, which is normal. We don't need, necessarily someone who has experience just in prosecuting cases. We need someone who has experience in administering a budget, which I have. Someone who has experience in developing and drafting government policy, which I have. Someone who has negotiated and dealt with complex issues regarding substantial amounts of money, which I have. Someone who has personally conducted, hundreds of investigations, which I have done. I'm done. Thank you.
Okay. Susan.
Yes, thank you. Well, in my years of 25 years in the district attorney's office, I've had a lot of opportunities to be a supervisor. When I was in the family support division for several years, after a few years, the chief of the family support division left, and I was in charge of the entire office for approximately six months. So I have that training in terms of supervising individuals. When I was in the military, of course, we get leadership training, and I also was, when I was in the military, I was a prosecutor. I was also a trial defense attorney for soldiers being charged with crimes in the military. My last assignment in the military was the chief of the Civil Division for 7th Corps. And this was during Operation Desert Shield, Desert Storm. So I supervised an office of 2 attorneys as well as staff. So I do have supervisorial experience. Now, as a senior deputy district attorney, I obviously have a lot of experience. I have had lots of attorneys in the office come to me to discuss cases and strategies for going to trial in terms of a possible disposition that would be fair and just. And so I do have that experience in being a mentor for people, and not maybe directly supervisor, they come to me for advice. Thank you.
Thank you. Next question, we'll start with you, Susan. Do you have any more holistic approach or suggestions to crime reduction other than the conventional approach of locking people up? Previous and existing solutions include diversion and drug treatment programs. Please offer your possible solutions. And let me just say to both of you, if you need me to repeat any of these questions, don't hesitate to ask, because we have several multi-parters.
Yes, I think it's important to look at being the head prosecutor as holistically, because we can't just send everybody to prison for as long as we can. There's been a lot of changes in California laws in terms of having people get out of prison early, with Prop 47, Prop 57, which just increased the credits that individuals get in prison. So it's important to have other things available for individuals who commit crimes. I'm a big believer in giving people a second chance, sometimes a third chance, if they show that they are truly motivated to change. But one thing that we can do is provide rehabilitation services for drug and alcohol. And if they have been, for example, if it's driving under the influence, it might be their 4th time, which is a felony, I would allow them to go to a 1-year residential treatment program, so they're off the street, give up all their credits that they've received while sitting in jail, and when they're on felony probation, if they violate, then they would go to jail or prison. I also believe in, I want to help establish with leaders in the community a youth program to prevent our youth going into joining gangs or getting in trouble after school. And I believe in mental health court, establishing a mental health court, as well as expanding our veterans court.
Thank you. Stephen.
As I said, I've handled probably, at this point, approximately 1,500 criminal cases. And it's true, I have not had a jury trial in any of those cases because I have been successful in negotiating dispositions in those cases. I have, as a defense attorney, gotten hundreds of cases dismissed and rejected because what I do is I put a lot of work and effort into a case, whether it be research or conducting investigation, interviewing witnesses, doing whatever needs to be done to represent my client in the best way possible. And I take that work to the prosecutor, and if I believe that it's a strong case, I will explain to them, here are the weaknesses in the prosecution's case, and they take my word for it, because if they didn't, they wouldn't have dismissed or rejected all those cases. I think well, in doing that, I have helped many of those people to get enrolled, and I think this is something that my opponent can't say, is that I have, as a defense attorney, worked with these individuals and getting them into these various programs, and made myself familiar with what the programs are and where they are and how successful they are, and assisted my clients when they fall out of the programs, getting back into them. So I think that I do know that there is value to these programs because there is a jail capacity issue. But I think that you need to be careful as a district attorney in allowing too many opportunities. There are some people who are not going to benefit from these treatments and who do need to spend the time in jail. I think that there is a problem with the current diversion setup, such that it's a kind of a one-size-fits-all. You've got people who are getting a drunk in public taking the same diversion class as someone who's operating a business without a business license. So I think that it needs to be. Okay, thank you.
Sorry about that. Next question. We'll start with Stephen. And this is a multi-part, so again, feel free to ask me to repeat it. What is the status of rape cases in Lake County? Do we have and use effective tools for prosecuting these cases? Do we have a backlog? What are the challenges of prosecuting rape cases?
I think rape cases are very similar to domestic violence cases. They're difficult to prosecute because there's rarely witnesses. I want to say that the Sheriff's Department I was just looking at some statistics today, and I think it was in the most recent that they had was for 2016, that there were 16 cases at least reported. The challenges of those cases are the same, as I said, with domestic violence. There's not very many witnesses. So you have to have a strong investigative team, and you have to be proactive with making sure that the investigation happens as quickly as possible. Something that I think is also important is ensuring that a victim is adequately kept up to date on the case as it proceeds. I think that there is a problem currently in representing, like I said, I've represented numerous crime victims, and I have heard a common complaint that they do not have the communication with the prosecutors that they would like to have, and are not kept up to speed on cases. In fact, there was a recent case where a man whose daughter was killed by an intoxicated driver, and that case was handled by my opponent. And the father, his complaint not only was that the person received a plea deal that is going to result in him being out of jail in 2 years, but also that he was not informed that this deal had been made. That's a problem. Any parent, would want to know I'm not saying that deal shouldn't have been made. Maybe there were weaknesses in the case, but communicating with victims is extremely important.
Thank you.
Okay, well, I'm going to try to answer that question as asked. So the question was about how many rape cases, is there a backlog, and what are the challenges in handling rape cases. Well, I have extensive experience in handling child sexual assault cases, which, when you think about it, there's so many similarities with dealing with victims of rape and victims of child sexual assault. because they are, of course, sexual assault cases. One thing that you have to do is gain the victim's trust, meet with them, talk to them, gain their trust, let them know what the court process is. One thing that we do with children, and I'm sure we could use the room for adults as well, is to videotape them once and ask them questions so they get their story out at one time and not have to have repeated questioning by various law enforcement. Our victim witness office is really, really good at keeping people informed of what's going on in any case. If the individuals contact the victim witness office, that I often tell people, please contact the victim witness office. If I'm not available, you can contact them. They will keep you up to date with what's going on in your case. So I think that we have to, we do have to treat these individuals with respect, and because they do face challenges, these cases do have challenges in prosecuting them. Thank you.
Thank you. Next question, we'll start with Susan. I think you've both probably alluded to this in previous responses, but we've got this question a couple different times, so we'll just ask it directly of you. And how many jury trials have you acted as counsel for one of the parties? And please state the types of cases represented.
Well, I've done over 100 jury trials. I keep track of them in my calendar, so I know how many I've done. And also, in the military, I was a prosecutor and then a defense attorney in the military. So in the military, I did many jury trials. In the military, it's a panel of officers, but it's like a jury trial. I'm sorry, what was the second part of your question?
State the types of cases.
Oh, the types of cases. When I was doing the child sexual assault cases, I did many jury trials, and those are the toughest cases to do when you're putting a vulnerable victim on the stand and they have to look at their perpetrator. Especially the younger they are, the harder it is. I learned in that, doing those cases and through my extensive training, how to make the courtroom a little bit more comfortable for them. I've had jury trials in murder cases, rape cases, violent and serious felonies, pretty much every type of case you can imagine. I've done jury trials or handled those cases. So I have extensive experience doing a jury trial. Obviously, I've also done court trials as well when that's in front of a judge alone. But my main training has been with jury trials. I also have had extensive training in doing trials.
Thank you. Stephen.
As I mentioned, I have not done a criminal jury trial, despite the fact I've handled many criminal cases, and the criminal cases that I've handled have ranged from petty misdemeanors to cases where people were shot, stabbed, killed, run over. So I have handled a lot of criminal cases. It's just that I've been able to resolve them in ways that were favorable to my clients while avoiding the expense and uncertainty of a jury trial. It's not that any of those cases weren't ready to go or couldn't go, it's just that the ones that were worthy of it were dismissed or rejected. I have no control over that. I have established a reputation as a competent and skilled trial attorney, though I have handled many different cases, ranging from domestic violence, quasi-criminal cases regarding contempt, restraining order matters, divorces, and the types of cases that I've handled have given me a lot of experience, because I think that this is probably, the types of cases that I've handled, family law cases, have involved all kinds of issues. Family law, when you're dealing with family law cases, they involve issues regarding tax matters, insurance matters, criminal matters, domestic violence, estate planning. So you have to be aware and familiar with all the different areas of law, not just one. And in a criminal case, you're trying to prove, the elements of the crime, whereas in a family law case, there are many different things you have to take into consideration. And the trials that I've been involved in, some of them have lasted months and weeks and months. So I have the trial experience, I believe, that is necessary to serve me, in being the district attorney. And as I mentioned, it's not just the trying of cases that's important. I think if you take someone who just has experience as a prosecutor, you might be losing a seasoned prosecutor and getting a bad district attorney. We need someone who's going to lead the office in the direction that it needs to lead. We need a philosophical change in the office.
Thank you. Next question, we'll start with Stephen. Over the past 10 years, California's legislature, as well as its voters, have enacted many changes that are impacting law enforcement. Those include realignment, Proposition 47 and Proposition 57. As you prepare to take on the job of district attorney, how do you plan on taking those changes into account? And how do you think they will impact the district attorney's office over the coming decade?
So I think this is the biggest distinction between my client and I. I think it's undeniable that there is mismanagement in the DA's office. Like I said, there are serious cases falling through the cracks, cases not being prosecuted on the merits. And I'll just give you an example. In 2014, there was a man who was arrested for being involved in a sophisticated drug operation. He had hundreds of guns, some of them fully automatic. And the sheriff's department spent hundreds of hours working on this case, investigating it and doing their thing. They turned it over to the DA's office, and it took 1.5 years for charges to be filed. That is common. I experienced that a lot as a defense attorney, and as a defense attorney I use it to my advantage because cases that become stale become ones that are easier to get worked out into the defendant's favor. Once charges were filed in that case, instead of serving the investigating deputy with a subpoena, which is the proper way to get people to attend court, they sent an email to his county email address. Well, that officer didn't work for Lake County anymore. He worked in Napa County, so he didn't get the email, he didn't show up for court, and the case had to be dismissed. Because felonies can be filed a second time, that case could have been refiled, but it wasn't. Another 1.5 years or so was allowed to pass, and the statute of limitations ran. So that case can't be prosecuted, and all those guns have to be returned to that person. I think whether you're for or against gun control, I think we would all agree that we don't want criminals having their firearms returned because the DA's office drops the ball. And I don't mean to say that I'm not criticizing people in the office. There are a lot of hardworking, good attorneys and staff in the DA's office. It's the leadership that's the problem. And I think that Prop 47 and 57 realignment, it's decriminalizing cases because of financial issues primarily, is my opinion. And I think that we need to, the DA's office has to do what it can to fight against that. Thank you.
Thank you. Susan?
Could you repeat the question?
Absolutely.
Thanks.
Over the past 10 years, California's legislature, as well as its voters, have enacted many changes that are impacting law enforcement. Those include realignment, Proposition 47 and Proposition 57. As you prepare to take on the job of district attorney, how do you plan on taking those changes into account, and how do you think they will impact the district attorney's office over the coming decade?
Well, ever since those changes have been in effect, I've been dealing with them since that time. The realignment law that made many changes in where criminals are going to be housed if they go to prison. It used to be all felony cases would go to prison, and only misdemeanors would be in our local jail, except for when they're pre-trial. Now, a majority of crimes go to jail, what I call jail prison, instead of state prison. And that causes overcrowding for the county, and it burdens the local county jail versus the state prison. One thing that I do is when I'm reviewing a case of charge, I always try to charge, if it's a felony, obviously, I always try to charge a state prison eligible case if I can. That doesn't mean I intend to say they're going to state prison, but I try to charge that so that relieve the burden on the local jail. Sometimes sentences could be 10, 15 years in the local jail, and they're not equipped to handle that. I know I have extensive experience with Prop 47 that reduced all drug possession cases to misdemeanors, as well as 47, and I have learned ways to deal with those cases. I also do agree, I do believe that we need to come up with better ways to handle those cases so we don't just send them to jail or prison in every case.
Thank you. Next question, we'll start with Susan. Do you intend to continue existing plea bargain policies? Do you have any modifications in mind other than generic and pointless tough on crime platitudes?
Well, can I say that I will vigorously prosecute serious and violent felonies? That's not a platitude. I do that every day that I go to the job. Currently, we have sentence bargaining in the office. Don Anderson implemented that when he came in. Before that, we had plea bargaining. We were one of I think only a handful of other counties that did not implement or use sentence bargaining. In our office, we use a combination of sentence bargaining and plea bargaining. And sometimes we even just do an open plea, and sometimes, a lot of times, we just go to jury trial if the individual is not willing to plead, or we think that the plea bargain that they want is unacceptable, especially in serious and violent crimes. It's very important when you are determining what a fair and just sentence bargain will be that you know sentencing laws. I just came from a training, extensive training on sentencing laws. They're very complicated in terms of credits, where they're going to be housed. So it's very important you know that law. I knew a lot of the law that I learned in the training, but there are still things I knew. My opponent has never had that training. I would continue to do sentence bargaining, but I would not allow for any public safety to be jeopardized by that. So I believe that I would have my own way. I would review every case that's going to be sentence bargained, make sure it's fair and just, and also keep in mind the judge is the one that makes the final determination of whether he will accept a plea bargain.
Thank you.
It's not accurate that I don't have training on sentencing. I do have training and experience, and I've handled cases that deal with that issue, so that's just false. In terms of plea agreements, for those of you who may not be familiar with it, there are a number of different categories of plea agreements. There's charge bargaining, there's count bargaining, there's sentence bargaining. Sentence bargaining, which is the topic that was raised, is allowing or entering into an agreement with the defendant that despite whatever probation's recommendation may be, that the DA's office will agree for a particular sentence, that the defendant will have a particular sentence if they agree to particular charges. There is value in sentence bargaining. I've used it many times on the defense end. The benefit that I've experienced, and I know that the DA's office has to look at, is whether or not the case has weaknesses. If the case has weaknesses, if you can still get the person to plead guilty to certain of the charges with others being dismissed and an agreed upon sentence, then it's worth doing that. I think that there is a tendency to over charge cases. As my opponent just said, she will charge cases that mandate a prison sentence when there's no intention to actually pursue that charge. I think that's a problem. I think that people should be charged with offenses that can be proven. That's an obligation of any prosecutor. Sentence bargaining, I would not engage in sentence bargaining for any reason other than out of necessity or because it was necessary in a particular case. I'm not going to sentence bargain cases in a manner that would put the public safety at risk. And I think that right now there's a tendency to try and make cases that are old go away or to up the conviction rate and get convictions. Okay, thank you.
Thank you. Next question, we start with Stephen. The district attorney's office has used asset forfeiture procedures and also has implemented a diversion program in which funds are donated to local charities. Concerns have been raised about how these programs have been administered. Would you continue them? And if so, how do you think they need to be improved?
I would not continue them, and that would be the improvement, is stopping them. I think that people should not be able to buy their way out of a conviction or buy their way out of the consequences of their actions. Money is an issue. I don't know if any of you attended any of the community visioning forums where they talked about, the economic situation of the county. I attended 4 out of the 5. And money is an issue in the county, and obviously it's a factor, but it's not more important than public safety. I can think of a case in particular where a defendant was arrested for exposing himself in the park. This individual had a lot of money and hired the right attorney, and instead of being prosecuted for an offense that would require him to register as a sex offender, he was allowed to donate money to a charity. And it's my understanding that he may have even purchased a playground. And then the person a deal was made that the person could plead guilty to offenses that did not require him to register. I'm a parent, and as a parent, that's a problem.
Thank you.
Yes, well, I wish you would not talk about cases you know nothing of. That's not accurate. What happened, at that time, there was no program with pay to a charity and get out of a case in that particular case. So you don't know the facts. So get the facts straight before you make those allegations. What I will say in terms of a program that you can pay a charity, basically the program was you would get a certain amount of work service and you can transform that into a money amount, and then you would give it to a local charity, and that would go in to help the local charity. I will not continue that program. I actually believe that work service and actually the individuals doing that work in the community is a benefit to that person as well as the community. So I think that it could instill a sense of pride in them. I had a case where I let the person do work service instead of jail. Saw him at the local hospice store doing a great job, and he felt good about doing it. So I think that's important, but I'm not going to continue a program where you can just pay a certain amount, even if it goes to charity, and get out from under any charges. In terms of asset forfeiture, I believe that's important. When you are dealing with drug dealers and they have a large amount of cash, you take their cash because it's profits from an illegal enterprise, and that hits them where it hurts.
Thank you. Next question, we start with Susan. Describe the case or client that presented the greatest moral or ethical dilemma in your legal experience. Why and what was your resolution?
That's a good question, and I'm trying to come up with something. Obviously, well, I'll just say that in general, I can't think of a specific case, but in general, domestic violence cases are the most difficult cases to prosecute because 95% of the time, the victim does not want to proceed, and in many cases, they will refuse to testify, and avoid service, and you can't really force them to testify under state California laws. I try to deal with the victims of domestic violence by meeting with them and talking to them, explaining that we want to get help for the perpetrator, go to anger management classes, go to drug and alcohol classes. We're not out to just send them to prison, but we want to get them help. But we unfortunately have some very serious domestic violence cases, and so those are a dilemma in the sense that I want to have a cooperative witness, but I don't want them to be hurt again. And so I have proceeded in jury trials without the witness there, if I can. So it's difficult. I don't like going against what the victim, if the victim doesn't want to testify, but sometimes I have to.
Thank you. Stephen.
Yes, I just want to refer back to the last question just real quick with regard to asset forfeiture. I think it's a useful tool. But one thing that I see happening is that the people engaged in criminal activity who accumulate a lot of money from their activity are able to essentially create this war chest, if you will, where they get arrested and the funds are taken in exchange for their case being dropped or reduced. I think that the assets should be pursued, but the case should also be pursued. In terms of moral dilemma, again, I think I'm having the same problem. I think that's a difficult question to answer. I think one thing I could say is that, a question that I get is, how can you go from being a defense attorney to being on the other side? And I believe very strongly in the Constitution and people's individual rights, and have enjoyed private practice where I help people to enforce their rights. I don't look at cases, it's not my job as a defense attorney to judge people or to have an opinion about them. Like a doctor, any patient that comes in, they're going to do their job and provide their services to the best of their ability. And that's what I've done as a defense attorney. The way that the system is supposed to work is the defense attorney is the voice of their client and represents them in an honest and ethical way as best they can, and the prosecution does the same. And somewhere in the middle is where justice happens. I think that there are cases that should probably go to trial, like the case that I was telling you about. Well, there are cases that I think get plea dealt out that should go to trial, and the reason that they're not, I think that they're not valid reasons. For example, worrying about the conviction rate or the jail capacity. The jail capacity is Brian Martin's issue. I think that if you make a policy that you're not going to prosecute cases for reasons like jail capacity, you send the wrong message.
Thank you. Next question, we start with Stephen. What solution can you suggest for the growing spillover of mental illness into criminal courts? Can you think of any proactive solutions, such as mental health court? And how do you see your role as advocate for these and other types of judicial reform?
Unlike my opponent, I have represented many people with mental health issues in criminal matters, and I have assisted them in navigating the legal system and seeking the treatment and help that they need. Also, unlike my opponent, I have been proactive already about taking this job seriously. I have gone on ride-alongs with every single one of our local agencies. I've done night shift with the CHP, Sheriff's Department, Clear Lake PD, Lakeport PD. I have sat down with Jeff Ryan in the administrative office on numerous occasions and talked to him about issues regarding the budget. And I have met with Todd Metcalf, who's the Director of Behavioral Health, and started discussions with him on how to streamline cases that involve mental health issues. I don't know that we've worked out any, in particular solution, but I am doing these things. My opponent has said that she wants to start a mental health court. She's been in the DA's office for 25 years, and she's never met with Todd Metcalf, the Director of Behavioral Health. She's never met with Jeff Ryan to talk about the budget. I think that the people want someone who's going to actually do things and not just say things. We need someone who is going to be proactive. And as I mentioned, that is exactly what I plan to do. I'm going to work hard and take the job seriously and put every effort into in making the needed improvements to the DA's office, and mental health is one of those issues. There are many people who get arrested for mental health issues. When they're on their medication, they're doing fine, but when they stop taking their medication and they start doing drugs, that's when they start engaging in criminal activity and they get arrested. There needs to be some way to streamline those people out of the system and get them out of jail, because obviously being in jail is not the place where they need to be.
Thank you. Susan?
Well, I first want to just respond to Mr. Brown's comment about he's proactive and I'm not. Well, I'm working in this every working day. I have gone to crime scenes where the murder victim is still there. So he's been on ride-alongs. I've gone to crime scenes and advised law enforcement personnel at the scene. Maybe maybe they need to do this, collect this as evidence, and see the scene on scene. I've helped them in the middle of the night. I've been called out to help with search warrants to be reviewed. So before they go to the judge, so that they're going to be correct the first time, and they're not going to, they're going to get past any type of motion to suppress. In regards to mental health court, I think it's vital that we have that established in Lake County. Obviously, the DA's office can't do it. It's a court, so it has to have the cooperation of the courts, the judges. But I am going to be proactive in getting that established with the cooperation of the judges. I'm going to, I see it's going to be vital in Lake County to get a mental health court. We have so many cases where individuals are in the jail for a few days because of a mental health issue, and then they're back out, but they don't get the help that they need. I am going to do whatever I can to establish a mental health court along the lines of a veterans court, where you get a holistic approach to dealing with individuals with mental health issues.
Thank you. Next question, we start with Susan. Outgoing District Attorney Don Anderson established a perjury unit, which he said is necessary to address the rampant issue of lying in court cases. Do you think this has been a worthwhile program? Will you continue it, or do you think resources are better used elsewhere?
I would continue it. I believe that it is important for individuals to know that when they go into court, and a lot of times this is in a civil situation where you're talking about child custody issues, and if one side commits perjury and they get a decision and a ruling in their favor because of that, I think that needs to be, they need to know that they need to respect the court and the court process, and they cannot come in and lie under oath. We also have, we have prosecuted perjury cases in many different types of aspects. I've prosecuted a woman for committing perjury when getting her driver's license. We also have perjury cases prosecuted in terms of getting welfare when they maybe are working and they have money coming in, and then they deny that and they sign a form saying that they don't have money coming in. So we have been prosecuting perjury cases all along. We just have not, we have just, with Don Anderson, we have started to focus more on the civil cases. So I would continue that program, and I think it's important. I think it can be a deterrent as well. If people know that they're going to be prosecuted if they lie under oath, that maybe they won't do it.
Thank you. Stephen?
I think that prosecuting perjury is an important thing to do, and there have been a number of cases where it's proven to be perjury has ruined people's lives, sent people to prison for years for things that they didn't do. However, I don't know that it's necessary to have a unit designated to this. I think that was more of a publicity stunt, in my opinion. I did a public records request from the DA's office, and the perjury unit, or judicial integrity unit, was started in 2016. And from that point in time until just a few weeks ago when I got the most recent update, there were 3 perjury convictions. I don't know that that's worth having an entire unit designated to handle this issue. I think that perjury can be prosecuted without this. I think that I don't even know, necessarily whether there's any specific more time devoted to that other than just calling it, a unit. One thing that I would like to see, and I've talked to the chief of police of Clear Lake, is a quality of life unit. I think that there are a lot of petty offenses that result in more serious criminal activity that happen in Clear Lake. And it would be nice to have that cleaned up. Right now there are a lot of murder cases going on in Lake County, and those cases, many of them, revolve around drugs in some way. So dealing with the petty drug issues could resolve a lot of the more serious issues, and it's the more serious issues that I am concerned about.
Thank you. Next question, we'll start with Stephen. Do you have any specific views on the effectiveness of the death penalty? Can you think of any situation in which you would choose to seek the death penalty?
So the death penalty is legal in California. I think it was most recently 66% of voters not only opted to keep it, but to make it more effective and expedient. However, and so I think by law, a district attorney has the obligation to at least consider it as a sentencing possibility in cases where it may be warranted. The problem with the death penalty is that no one is ever put to death. I think that January of 2006 was the last person that anyone actually was executed pursuant to the death penalty in California, and I think that we're approaching nearly 1,000 people on death row, which I think is more than any other state. So the short answer is, I think that the job of the prosecutor or the district attorney is not to make law, it's to enforce the laws that exist, whether you agree with them or not. And I think that there are cases where it may be warranted, and so I wouldn't rule it out or say that it's going to be something that is considered every time. I think that it's something that has to be considered when the circumstances are appropriate.
Thank you. Susan.
Well, I actually agree with Mr. Brown on that one, and I agree that as the head prosecutor for the county, you can't rule it out 100%. You can never say never, I would never do that. I will say that I do not think it's an effective deterrent. It's been proven not to be an effective deterrent, and the problems with it are that it delays a case substantially, so the victim's family of a death penalty case, it could go on for years and years and years, and they never get closure, and of course, nobody is actually executed, so then they have that year after year. They always have to wonder, when is this going to end? It's been proven to be not cost effective. It costs more money to pursue a death penalty case than putting a person in prison for life. So I don't think it's an effective deterrent. I don't think that it's effective financially, and it's not effective for the victims. But I can't say I would never pursue it, and I hope that we never have a case in Lake County where we where we might need to.
Thank you. Next question, we start with Susan. This one comes from the audience. The California canons of judicial ethics bar judicial candidates from making any endorsements in other campaigns. However, candidates for the DA's office are not barred from making endorsements. Are you prepared to endorse a judicial candidate now? I think there might be one in the audience that submitted this, but I'm not sure. I'm just guessing.
That is, that really does put me on the spot. I am not prepared to endorse a judicial candidate at this point, but I think that one problem is that, you know, as a attorney in a deputy district attorney or the DA, I'm going to have to work with whoever's elected judge, and don't want to hear that admonition the judge will be giving every time. I just have to say that this person endorsed me or whatever. So, but I have a lot of respect. I have a lot of respect for Shanda Harry. I worked with her in the DA's office, and I say this about myself, that I think it's time to have a woman, and as a judge in Lake County. We've had one in the past, many years ago. I think it's time to have a woman. I think it's time to have a female DA. There's never been a female DA in Lake County, and not just because we're both women, but we're both qualified. Thank you.
Thank you. Stephen?
No. I'm not endorsing anyone for judge, but I would say that I would implore any voter to vote based upon the individual and not based on gender, as my opponent seems to think is appropriate.
Thank you. Okay, the next question will start with Stephen. The county correctional facility is overcrowded and understaffed. How would you balance your sentencing recommendations with community safety, just incarceration, and criminal rehabilitation?
Public safety is the primarily the importance of what I'm running for. I think that the jail capacity is not something that, just like it's not something I don't think that the judges would take into consideration. It's not something that the DA's office should take into consideration. The jail capacity is the responsibility of Brian Martin, and it's the DA's job to prosecute cases based upon crimes that are committed and to ensure public safety. I think, as I said before, creating a policy to prosecute less cases or not prosecute a set of what you might consider petty cases because the jail is too full sends the wrong message. Even if you are going to have some type of a policy, you would certainly not want it to be known publicly. I think that there are some intelligent criminals out there, and they figure out that, hey, I can commit this crime and no one's going to stop me because the jails are full. I think that's a problem. Every person, I think the potential for jail is a crime deterrent. I think that it's important to have that policy, that everyone knows that if they commit a crime, they're going to be prosecuted, and whether they actually serve jail time or not, you don't have control over that as a district attorney. That it will play itself out, and again, if the jail's full, then it's full. But I don't think that it's something that the DA's office should consider, and the DA's office has to be primarily concerned with ensuring public safety and prosecuting cases based upon the crimes that are committed.
Thank you. Susan?
Well, I believe in, again, alternatives to jail, and in certain circumstances, it increases public safety rather than causes a concern about public safety or is harmful towards public safety. Now, here's where it's important to know our sentencing laws. They're very complicated, and you need to know what they are in order to come up with a just plea bargain or a sentence bargain in regards to jail time versus other alternatives. Now, I will say that right now, the jail has a policy that you're eligible for work service. In other words, if you get a 90-day jail sentence or less, you can do work service instead of that jail time. A lot of people don't realize that, for example, if you have a fourth DUI, if you get the upper term on that, you would go to the jail prison for 3 years, and you get half-time credits, and even more than that. It would be, and then they're out. Then they're done, and they're not supervised at all. Another alternative would be, okay, give them a minimum jail sentence up to 180 days, 200 days, up to a year. And then put them on felony probation, make them do a Johnson waiver so they give up all of their credits. They're on probation. If they commit a crime again, violate probation in any way by drinking alcohol, for example, they could go to jail, and that would be the sentence hanging over their head. And I think that's a better way than just having them serve their sentence and then they're out and they don't have any supervision whatsoever.
Thank you. Next question, we start with Susan. What impact do you expect the legalization of recreational cannabis will have on the DA's office? As district attorney, what types of marijuana-related cases would you expect to still prosecute?
Well, I think I will still prosecute. Well, there's obviously, it's still it's a misdemeanor to possess marijuana for sale. So there are those cases, but I will definitely prosecute cases when there's a marijuana grow, cultivation that is doing any harm to the environment. And we can charge felonies for those. So when you have a large grow, and I've prosecuted these cases, so I know that people divert streams, they use other people's water, they dump chemicals, people obviously up on public property, it's not even their property, so I will prosecute those cases if there's any environmental crimes, and I will charge felonies for that. There is a California law has changed so that there will be individuals who will be licensed to grow marijuana, and then there's going to be a lot of black market marijuana. So I would probably prosecute once the system in California is established, or in Lake County, I mean, then I would, where people are licensed and they're using the safeguards that are required versus the black market people, I would have to take a look at that. The other thing that I will do is it's a felony to export marijuana out of state, so I prosecute that as well.
Thank you. Stephen?
I think the effects of the change are still developing. I don't know that we've seen the full effect yet. I think that ultimately it will probably result in less marijuana cases being prosecuted, obviously, because it's being decriminalized. The types of cases that would still, any marijuana-related issue that's criminal would obviously be something that could be prosecuted, because again, that's the job of the district attorney, is to prosecute criminal activity based whether they agree with it or not. But the cases of primary importance would be grows on public lands, grows on private lands where the owner has not given permission, trespassing, environmental grows where they're doing environmental damage. Those, and crimes, robberies, burglaries, the crimes that don't just revolve around marijuana, but all drugs. There is a significant methamphetamine problem that really needs to be dealt with. Those are the issues of primary importance for me with marijuana, is the crimes where people are being affected by it.
Thank you. Next question, we start with Stephen. Okay. There is a perception of ethical violations by the current DA, including the alternative sentencing program, to using a county car, phone, and office space while conducting private business. What assurance can you give us that you will strictly adhere to the highest level of ethics when you are elected?
And again, I think this is the biggest distinction between my opponent and I. I announced that I was going to run against Don Anderson because I observed, along with many people, that he was mismanaging the office, and like I said, in many different ways, and engaging in things that he probably shouldn't. And that's why I chose to run against him. I chose to run against the incumbent and asked a number of other people, and they were not going to do that. If I hadn't announced that I was going to run against the incumbent, he would be running for re-election unopposed, and my opponent would not be sitting up here. My opponent is not running to make the types of changes that need to be made. She is not willing to acknowledge that he has mismanaged the office, even though it's undeniable. That's a problem. That's concerning. The fact that my opponent would not run against the incumbent, despite the fact that he's mismanaging the office, which is occurring in front of the everyone in the office's eyes, but instead thinks that she has to run against somebody from an outsider who's coming in to fix these problems. That's concerning. That's the biggest difference between my opponent and I. She's running to maintain the status quo, and I'm running to implement the philosophical and ethical changes that need to be made in leadership.
Thank you. Susan.
And we have yet to hear any of those philosophical changes in leadership or ethics that you claim. You said you ran against Don Anderson, and you're still running against Don Anderson. You cannot say anything about me in terms of my ethics, and I challenge you to say that I have ever been unethical in my entire practice as a deputy district attorney and in the military. So I am going to be my own DA. I have policies that I will make. I would guarantee you that I will work hard every day for this county. I do that all the time. I'm there on the weekends. I'm there late at night. When I'm in trial, I've been there till midnight. And it's the old jail. People died in there. It's scary. But I'm there because I have to be in court the next morning. So don't tell me that why I'm running. I'm running to lead the prosecutors in the office, because it takes a prosecutor to lead prosecutors, because civil attorneys, they don't speak the same language. You can't tell a prosecutor in the office, you need to go to jury trial on that one, because you've never done a jury trial. I will maintain and make sure that everyone in the office maintains ethics. Don Anderson is not going to be the DA. He's not going to be in the office come January. So he's going to be gone. If there's ethical issues that he's had in the past, he's not going to be in there. Thank you.
Thank you. Next question is start with Susan. This isn't a multi-parter. This is one quick question.
Okay.
What's the most critical skill a DA must possess?
It's a quick question, but not a quick answer. I think most critical skill. Well, I said before, doing jury trials is our bread and butter of a prosecutor, any prosecutor. But it's not just that we have to do a jury trial in every case. But you cannot judge how to handle a case, or what plea bargain, or whether or not you need to dismiss the case because of lack of evidence, until you have some jury trials under your belt and have gone to training. A lot of crazy things happen in jury trials, and you really have to be prepared for that. So I think that that's the most important skill, and it's most important as a DA, because then you don't have any credibility when you come into the office and you've never done a jury trial.
Thank you. Stephen.
Can I get the question again?
Sure. What's the most critical skill a DA must possess?
I think being an ethical leader and acting in, I mean, a district attorney is someone who has to exemplify the highest level of ethics and essentially maintain their life in a way that they're requiring everybody else to. That is the most important thing that I think is requirement of the district attorney. In terms of credibility with prosecutors, I have credibility with them. As I've mentioned, I've handled approximately 1,500 criminal cases, so that's on average 185 each year, and I've gotten hundreds of them dismissed and rejected, cases that I was prepared to take to trial, cases that went all the way up to either the preliminary hearing, where my client was facing serious charges, including strike offenses, and the charges get dismissed, or some plea deal is made because I'm ready to go, and I don't have any control over that. So I do have credibility in the office, because if I didn't, they wouldn't take me seriously when I show up prepared in court or in their office to talk about a case, and they take my word for how a case is going to pan out, and the case gets resolved that way.
Thank you. Next question, we start with Stephen. Both of you have probably touched a little bit on this, but this will give you a chance to expand on your thoughts. What's the greatest need of the district attorney's office? What specific policy or program would you implement to address that need?
I think the answer is probably very similar to the last one. I think we need an ethical leader who's going to stand up for and do what is right, even if it means that someone's feelings might get hurt or that they might be upset. I am the only person that challenged the incumbent. I think many people wanted to, but they didn't. And I think that's a characteristic that I have shown, and that is characteristic of a leader, someone who, I've put myself at risk by running. I put my own, job at risk where, I'm being, probably replaced. I used to be able to get amazing deals for my clients, which will probably not happen, if I'm not elected, because I've, come forward and said those things that need to be said about the district attorney. I think that is why I'm running. That is what the office needs, is a leader who's going to stand up for and do what is right, even if someone's feelings might get hurt. Yes, I did announce to run against Don. I like Don. I think he's a nice guy, but a better job can be done. And I was the one person who was willing to stand up and challenge him.
Thank you. Susan.
And once he left the race and ran for judge, you're still running, so there must be other reasons. But do not, I know you're trying to bring me into this where you're trying to say, I'm Don Anderson, just because I didn't run against him. I am not Don Anderson. My ethics are 100%, and you can ask anybody in the office. And you need an ethical leader. I am a proven ethical leader. I don't see, the proof is in the pudding, basically. Just because I had my own reasons for not running, you don't even know what they are, but I had my own reasons not running. But once I saw that Don Anderson was not running, and we would have somebody in the office that doesn't have the training, the skills, I had to stand up, because the DA's office needs somebody who could take the reins from day one, somebody who has the training and experience and talk to prosecutors as a prosecutor. So I agree that we need somebody ethical, and I am that person to take the job next year. Thank you.
Thank you. Okay, we're going to start winding down. We've got a few questions left. If anybody has a pressing one from the audience, we'll try to fit it in, but we've had a lot of great questions, so we're going to go to the next one, and Susan will start. What are the 3 most important changes you hope to accomplish during your administration?
One important change is we need to update our case system. It's really antiquated, and it's very difficult to update the system, get full information from the system, and I believe we are in the process of doing that, but I want to take it one step further. I want to establish, see what new programs, technologies we can use in the office to bring us into the 21st century, so to speak. I think it's really important, because right now we have paper files, and I like paper files, but I think we need to update our technology in the office. I will continue sentence bargaining, but I will do a combination of sentence bargaining, plea bargaining, and sometimes open pleas. I will make sure that we treat everyone fairly, and there's been some allegations of preferential treatment by, again, Don Anderson, not me. I will never treat anybody differently because of who's charged with a crime because of their status, their job, or any reason. People need to be treated fairly, uniformly, and they need to get a similar sentence for the same charge, considering their background, their criminal background or lack of. And so I will make sure that that happens, that everyone is treated fairly, and I will also make sure that everyone is treated with respect in and outside of the courtroom, and including the defendant.
Thank you. Stephen?
I agree. I think that improving the technology of the office is an important thing to do, and I would look very seriously into doing that. And as I've said, I'm the only candidate who's actually met with Jeff Ryan to discuss the issues regarding the budget. I think it would be nice also to replace or get back positions in the DA's office that have been cut due to funding issues. That might be something that I'm not able to achieve simply because of the financial state of the county, but that's something that is important to me. I think restoring victims' confidence in the system is of most importance to me. Like I said, I've represented a number of crime victims. I've represented many people who were the victims of domestic violence and assisted them with both having a criminal case proceed and in civil, obtaining restraining orders in civil cases. And I've talked to a number of crime victims who have lost faith in the system for various reasons because of deals that were worked out that they didn't know about, or just the way that a case unfolded. Even if a plea deal is made in a case, it's extremely important to communicate with the victims and let them know what's happening in a case and why. Letting them find out from people in the community, that's not fair to them, and it's a problem. And that's something that's extremely important to me, is restoring victims' faith in the criminal justice system. And putting public safety first above anything else. I would, in terms of the conviction rate, yes, it's great to have a high conviction rate, but I'm not going to put the conviction rate as a priority over public safety. If a case is worthy of trial and it goes to trial and the jury finds the person not guilty, then the system did its job. But I would rather hold my head high and say that we did our best in the case than to. Thank you.
Thank you. Okay, so last question, we're going to do a little something different. We generally try to ask you each the same questions, but we've gotten some questions specific for each of you, so we're going to do something just specific for each of you. You will each answer your specific questions. So we'll start with Stephen. Your father is a county supervisor and has a bail bond business. With USDA, isn't that a huge conflict of interest?
No. It sounds good, to say that there's a conflict of interest. But in terms of him being a supervisor, I don't think he's going to run for re-election. But even if he did, he would do the same thing. Well, first of all, the Board of Supervisors don't oversee the district attorney. They oversee some aspects of the district attorney's office, such as the budget. But my dad would do the same thing that he did when I was on the public defender contract for 3 years, which is recuse himself from any decision that is made regarding the DA's office. So that's a simple solution. That's not something I can do. That's something that he would do, and I'm sure he would do it because he's already done it. With regard to him being a bail agent, I also don't believe that there would be a conflict. The DA's office received 4,886 cases last year, and my dad did 200 bails. So that's about 4% of the cases that the DA's office sees. So it's a small amount. And as a defense attorney, I have the same ability to affect a defendant's bail as a prosecutor does. I could very easily convince my clients that I'm not going to make a motion for their bail to be reduced or for them to be released on their own recognizance, but I haven't done that. And in fact, I've gypped my dad out of tens of thousands of dollars by getting people released, and I've done it against my opponent. And if my opponent had been a stronger prosecutor, my dad would have made more money. But I'm not in it to, do people favors. That would be career suicide. I want to be a successful attorney, just as I would want to be a successful district attorney. And I'm not going to jeopardize my career to do him any type of a favor. That wouldn't make any sense. And I've done that as a private attorney. The prosecutors, they don't even know who the bail agent is in cases. The bail bond goes directly into the court file and they don't look at it. They might find out during a bail review hearing, but that's a very rare case. And something that a prosecutor would be doing is seeking to increase bail, which decreases the chances that a person is going to make bail. So again, the conflict thing, it just doesn't make sense. Sounds good though.
Susan, you've heard a lot of criticisms of the district attorney's office tonight, both from your opponent and in the form of questions raised. And so I'd like to ask you, are those criticisms fair?
Well, I don't think it's fair if it's a criticism, it's being used as criticism against me. I don't think that's fair. You can have your opinions as to what Don Anderson is, how he's been as a DA, but and those may be fair. As I said, I will be in the office. I won't take private cases. I don't believe in that. I would never do that. I will be there, regular schedule. I'm not going to take a lot of time off, but I will do things differently. But here, it's not fair to basically bring me into everything you dislike about Don Anderson because that's the person you're still running against, and saying that I'm just like him. I'm not. I've had arguments and disagreements with Don Anderson from the beginning. And he's the first person that would admit that. But in the end, in my position as a deputy DA, it's not my position to go to him and say, you're doing this wrong, and if you don't change, what am I going to do? He makes the policy. He was the one elected, and so ultimately, I'm not his keeper in terms of seeing everything that he's doing and telling him he's doing things wrong. I know how I handle my cases, and I've handled my cases fairly and with public safety always in mind, sentence bargains that are fair and just, approved by the judges who are the ultimate deciders and can say, well, I'm not accepting this plea bargain if they don't think it's a just situation. So I think that, I'm not Don Anderson.
Thank you. Okay, well, that was a lot of ground to cover.
Yes.
So we're going to move into the closing statements. And this will be your time to really talk about anything you'd like to. You'll each get 2 minutes to wrap up. If there's anything possibly we haven't asked you about, feel free to bring that up or just even touch on something previous. Anything you'd like, it's all up to you. We will go in reverse alphabetical order for closings, so we'll begin with Susan.
Okay, thank you. Well, I really want to thank Lakeco News and the Bar Association and the Economic Development Corporation for putting this on. I really appreciate the opportunity to talk to people, and I know it's being recorded and it'll be put on the Lakeco News so that more people can see this. It's important that people know who their next DA is going to be, and that person should be me. I can lead from day one going into that office. All I have to do is change offices, and that won't take me long. I have the training is so important as a district attorney. It's a lot different than any type of training that you would get as a civil attorney or even as a public defender. I have that training. I have the experience, not just with jury trials, but also the experience to know what is a proper and just disposition in a criminal case. We can't take every case to trial. The courts would be clogged. We wouldn't be able to, we don't have enough judges to take every case to trial. My opponent has basically said he would not do any sentence bargaining where it involves public safety, and that's a lot of cases. So we're going to be going to a lot of trials. In actuality, we're going to have to dismiss a lot of trials. I am the best choice. I've been serving Lake County as a public service for the last 25 years. I served our country as a public service in the Army, as a public servant in the Army for 7 years. I'm the best, most qualified person for this job, and I ask for your vote. Thank you.
Thank you. Stephen.
I am not accusing my opponent of condoning Don Anderson's behavior. The thing that I'm trying to point out is that I am the only one that challenged him, even though his mismanagement was undeniable. And people want to know why I'm running. That's why I'm running, because the office was being mismanaged and no one was going to do it. And if I hadn't done it, it would be mismanaged for another 4 years. And I was not willing to allow that to happen. We need a leader who's going to step up and do what is right, even if someone's feelings might get hurt, or to challenge, those people in power. I have established myself as a competent attorney. I've been practicing for 8 years. I've handled approximately 1,500 criminal cases. I've established a reputation as a competent trial attorney, and I think we need a district attorney who is going to be forthright and honest with you. I have not done a jury trial, but I've been honest about that. My opponent has claimed in radio interviews and at the last debate, I didn't hear it tonight though, that she has prosecuted hundreds of thousands of cases. That's not humanly possible. It's far less than that. I have been honest with you. In comparing my opponent to Mr. Anderson, the point that I'm trying to make is she is more concerned with an outsider coming in and fixing problems than she was with the mismanagement of the office. She was willing to allow that mismanagement to continue to happen. That's a problem. My opponent has experience as a prosecutor. She does not have experience operating a budget. She does not have experience developing and drafting government policy. I believe that I am a far more experienced negotiator and have dealt with cases that involve complex issues involving substantial amounts of money. Those are all very important parts to what the district attorney would do. Lastly, I'll just say thank you all for coming out and listening. The fact that you're here and concerned, whether you're voting for my opponent or me, is important. And thank you, Susan, and thank you, John and Elizabeth.
Thank you. So that ends our forum for tonight. Thank you both very much. Thank you, Susan, and thank you, Stephen. That seems like a lightning round, but thank you very much. We've got two great candidates, everybody. Thank you very much to all of you, and we will, and again, thank you to the Bar Association and the Economic Development Corp for their partnership. Thank you, everybody. Good night.